Alex here with part 117 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex-parental rights have been terminated. Number two, the nutshell version, as the purpose of the series has to do with providing my viewers with one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We move on now to a motion to modify child support. Some people might ask, why would you file a motion when you have another motion already pending, and then you also have a completely different case that you've opened up that's also pending? And this is the point where I start to realize that you should file papers when they have merit, and you should avoid trying to work around the court's dysfunction to the extent that your rights aren't being exercised. So, I mean, you do have to work around the court's dysfunction to a certain extent, but when it comes down to your rights being affected, that's, I think, where I draw the line. In the video, Attack, 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 I explain this. A lot of people look at the title and they think that it means file a whole bunch of things, even if they're frivolous, just to stress out your opponent. That's not what it means at all. What I'm trying to say in that video is, if you need to bring an issue to the court and the issue has merit, file the paper. Don't hold off just because you have other things pending or because you're afraid that it might be too soon after your last motion. The Supreme Court of Nevada at least explains that you can't be punished unless you're filing something that lacks a basis or something with the intent to harass your opponent. They don't allow judges to just say, okay, well, since you filed 3 things, that magic number automatically means you're a bad person and you have to, pay fines. And the same thing goes for, since you filed something 4 days after the last order was entered, same thing. Those magic numbers mean nothing to the Supreme Court or to the Court of Appeals, at least in Nevada. The court has to show that a particular filing, even if it's just one filing, let's say you didn't file 10 documents, let's say you just filed one single thing. If that one single thing lacks merit or was filed with the intent to harass, then you can be sanctioned. Too many judges in this state, and other states, I guess, like to sanction people just because they filed a specific number of papers and it's too many, it's too much work. Anyway, I talk about this wrong-headed approach to practicing, well, not to practicing, to sitting on the bench in the video. End of filings is not end of abuse. I bring it up a lot, but so many judges make this mistake that I have to bring it up to let my viewers know what they're thinking when they do these things. Anyway, motion to modify child support because my income has, gone down a certain amount. And I can vaguely recall that this is when I was working at the collection agency where the commission checks really went down after I ran out of a certain number of accounts. I hope I mentioned this in the paper, but just in case I don't, what happened was when I took on this role at a collection agency, I found a backlog of several years worth of cases that hadn't been pursued. And so I pursued all of those cases in the backlog from my predecessor, and I was able to get pretty large commission checks because my predecessor hadn't done that work. Once I caught up on all those cases, the backlog was gone. And so there was no way for me to keep doing what I was doing before because now I was current and I was only able to, collect on the current cases that came up. All of the cases from the past were either resolved or they were out of statutes. So anyway, that is the reason that I filed this motion to modify child support. And this gets pretty hairy, and I'm going to avoid reading into the future on this one. Let's just kind of go along with this one. And with all that being said, let's go ahead and take a look at what I have filed. Here we are with my motion to modify child support. Going into the first paragraph, I identify myself as a petitioner, indicate to the court that I am representing myself. I have no attorney. That's what I mean when I state appearing a proper person, and that I file a motion to modify child support. Let's go on into the factual background. On August 25th, the court awarded, well, I guess it's just a summary as to the dispute between myself and my ex. We share a common child of age 6. In the next assertion, the court awarded physical and legal custody jointly. In the next assertion, I was employed full-time by a collection agency, and I enjoyed a $12 per hour salary with lucrative bonus program. Next assertion is that my ex filed a motion to modify child support in response to my elevation in employment. Next assertion is that I switched full-time to another job, public interest law firm, and this position did not include bonuses, and therefore my income decreased. Oh, I'm already getting annoyed. The reason being, what the judge does under the situation is so bad. Let's just get to the actual hearing. Okay, I didn't know it was as bad as you know. Sometimes I think the judges make mistakes because it's plausible that they didn't mean to do it, and then I go through this case, and it's like so many way out of this world level mistakes, like stuff that's consistent with midnight exchanges for an infant. Anyway, moving on. Or a 2-year-old. Switched full-time employment. Okay, so I already covered that. Let's see. Parties stipulated, so we agreed on my ex's motion to modify child support. Next assertion is that I was rendered unemployed after the public interest law firm disbanded. The owners of the corporation were sued for fraud and misrepresentation. That's true. So there's another case open, I guess. Oh yeah, this is their case. Okay. Next assertion is that I was employed by Collection Service in Nevada. Part-time paralegal, $15 an hour. The hours were substantially lesser than those of my previous 2 jobs. And I'm accelerating my my students. Okay, what am I saying here? Oh, I upgraded. Okay, so from part-time to 3/4 time, and I'm accelerating my rate towards graduation. Yeah. It's like, oh, this judge. The reason I'm frustrated is because this judge uses willful underemployment when you're not supposed to do that when somebody's going to school, because they're not willfully underemployed for the purposes of avoiding child support. They're willfully underemployed for the purposes of bettering their life. And here's the irony in all of it. The amount of income that I was making in these jobs was so low compared to the amount of income that I started to make after I graduated with my degree in computer science and engineering. And the judge was so short-sighted that he couldn't understand such a basic principle. It's like he couldn't get his head around the fact that somebody who's making a small amount now is going to complete their degree and make 5, 6, 7, 10 times as much, and the child support is going to increase after they get their better job. And it's like he didn't understand. I just can't, like, some of the mistakes that judges make no sense at all. It's like even ordinary people with no degree can understand these principles, yet they can't understand them. And it's so difficult for me to try and figure out why they do these things as judges. And that's probably why I came up with videos like self-representation bias, because there is no logic or wisdom behind these mistakes. It just comes off as they have a lawyer, you don't, they win, you lose. And that's it. And that leads to some of these crazy decisions. And I also talk about this in the video Meta Rulings. I don't think I mentioned that video often enough, but take a look at the video Meta Rulings, because in that video, I get into judges who make decisions not based on the law, but based on what they want you to do. And they make these decisions that make no sense. And they don't even realize it sometimes, I think. So anyways, guys, we have a judge here who's going to say that I'm willfully underemployed for the purposes of avoiding child support, when what really happened is I was willfully underemployed for the purposes of quintupling my income, which is going to, result in an increase in my ex's child support anyway. So this is, and by the way, she's not even getting child support at this point. She's actually paying me child support. So if this judge would have had the ability to see beyond his nose into the future, he would have seen that my ex's child support was going to not only be eliminated, but I was going to end up having to pay her. But he just could not understand this. We're going to go to an actual hearing, and you're going to get to see this judge making this colossal mistake on your own. So just bear with me, because this will go to a hearing, and I do have the video, and I'm excited to show you guys just the type of nonsense that the average litigant goes through in these cases. You're just going to have to see for yourself to really understand what I'm talking about, because it's hard for I think people to believe this. You just have to see it with your own eyes. It's just one of those things. All right, next assertion here. Rivero v. Rivero, 2009, which discusses not only the joint physical custody presumption, but also the way that child support works when 2 parents have joint physical custody. And that's the Wright v. Osborne case that's mentioned there. I've talked about these before in various other videos, so I'm going to glaze over it. This goes into the computation, which I've talked about in previous videos. If you want to know more about this, you need to look at the video child support, guys. I'm not going to just talk about all these things again because I already have a video that I reference. Going more into the formula, or no, this is a specific case where the Supreme Court mentions that they have consistently found error when the trial court invents its own formula for calculating child support. Substantial decrease in gross income mandates review. This is the Rivero case again, citing a law which states that if your income has decreased by 20% or more, then the court is required to review the child support order. Here we have my last 6 paychecks, which indicate a decrease. 39% decrease. I'm getting even more annoyed again. Because to punish a parent for a 39% decrease in income, we're back to egregious. The mistakes aren't even slight. The mistakes are egregious. Moving on to willful underemployment. I shouldn't even be talking about this. Okay, so the reason why I shouldn't be talking about willful underemployment is because this is something that your opponent is supposed to bring up. But I'm dealing with a judge who makes mistakes so often that I'm starting to anticipate the mistakes that he's going to make. And by anticipating the mistakes that the judge is going to make, I'm starting to bring up points of law that my opponent should be the one bringing up first, that I can discuss them on reply. So guys, don't do this. Even if your judge is making mistakes, even if you have an incompetent judge, follow the normal briefing pattern, because it's just going to complicate things on appeal when you do it this way. So if you file a motion, bring up what favors you in that motion. Wait and allow your opponent to bring up what favors them on opposition. That's the normal way that briefing goes. You file what favors you in motion, your opponent files what favors them on opposition, and then you on reply get to address the things that they brought up on opposition. I understand why I did this. I really didn't understand how law worked. I didn't know how to work around this specific judge's dysfunction, but I'm trying to tell you guys, don't do what I did. Don't bring up points of law that are unfavorable to you. Let your opponent do that, and then you can address those on reply. Anyway, this law provides that a person can have their income imputed if they are willfully underemployed for the purposes of avoiding child support. If they are not doing it for that purpose, you can't use that law. Now, my understanding in Nevada is that this law has changed. I'm not sure how it has changed, so this stuff may still apply to you guys, but definitely if you're in Nevada, take a look at the updated statutes, because this may or may not still be the case. Next, we have I am mentioning that although my student's status has increased from part-time to 3/4 time, it's merely me taking advantage of the economic decline. It could serve to preponderate that I'm willfully underemployed, but, and if you go into this case here, Miniar v. Miniar, the Supreme Court of Nevada is saying that willful underemployment in and of itself is not enough to impute income. In fact, I saw the Supreme Court of Nevada overturn a decision not even a week ago, I think 5 or 6 days ago. A judge stated that a father was willfully underemployed. He imputed his income, and the Supreme Court reversed and sent it back, telling the judge that that wasn't good enough, that he also had to make a finding that the father was willfully underemployed for the purposes of avoiding child support. That specific section of the statute is crucial. Again, guys, the law may have changed, so definitely do some research if you're in Nevada. I'm mentioning here that if I become a software engineer, my income is going to increase dramatically. And I'm mentioning further here that my increase in income will overcome the presumption that I am underemployed just because I want to avoid child support. In fact, if I graduate, it would eventually liberate my ex from child support entirely and would have me be paying her child support. So I'm trying to get the judge to look far into the future and to pay attention to the law and to pay attention to what I'm trying to do for our son and pay attention to how it's going to impact my ex. He's not going to do any of that nonsense. That to him is nonsense. To a normal person, that's logic. And what he's going to do is impute income. And I'm really frustrated by it because of the way that he actually was able to get me from getting access to the Supreme Court. All this stuff is going to come up soon. We're going to talk about this as it comes up. But guys, eventually I do graduate and my income shoots up, and my ex would have gotten child support at that point in time, but the new judge takes over and deprives her of physical custody, which thus deprives, well, I wouldn't say deprives, it, I guess you could say alleviates me from ever having to pay her child support anyway. Moving on into child support should be modified nunc-pro-tunc. What I'm citing here is a law called Ramacciati v. Ramacciati, which allows me to get the court to modify child support back to the date of the motion. The court can't go back any further than that, but the court can go back to the date of the motion. Now, my opinion here is that This case, unfortunately, says it's discretionary with the court, which I strongly believe actually incentivizes attorneys into playing games and deliberately dragging their feet. This actually creates more work for the courts. I think the judges and attorneys know this, but they don't care because they can exploit this as an opportunity to litigate more and, of course, charge more money. But my opinion is discussed in the video Child Support, which states that they should mandate retroactive modifications to the date of motion because that would actually encourage settlement, which would discourage litigation, which would eliminate pointless hearings and actually decrease the costs for both litigants in these child support disputes. But that's my opinion. That's obviously what would occur. And right now, even to this day, that is still not the law in Nevada. So it's a disappointing conclusion, I think, but it also, in a sense, supports a lot of those claims that people make in these documentaries, stating that the attorneys are more obsessed with making this a business, a profit center, rather than actually what's in the best interest of the parents. And this is one of those things that glaringly stands out to me as something that supports that specific allegation or assertion. If you guys want to talk more about why this is crucial, let me know in the comments below, especially if you've watched the video Child Support and it still doesn't make sense to you. I'm thinking about elaborating on this in a separate video because if you haven't gone through this, you won't know why it's so important to mandate retroactive modification of the date of motion. If anyone's gone through this, they will know because they'll have seen it actually for themselves with their own two eyes that their opponent is deliberately not agreeing on the amount just to drag out the process to get a few more months of child support in there that's favorable to them, which I think is wrong. And all it does is create more work for the courts. But as I mentioned earlier, more work for the courts is also more money for the attorneys involved. Moving on to mediation is futile. We have, okay, this is the boilerplate language I include into all of my motions to get me out of mediation. I don't want to go to mediation anymore. It's a waste of time with my ex. Moving on to hearing, I would prefer to resolve the matter without a hearing because it's primarily an exercise in number crunching. The court could enter an order for review requiring us to file briefs in substantively applicable law, as well as whether financial information is deemed necessary. This ends up going to a hearing anyway. Sometimes I wonder if the court kind of just, what's the word that they use? Reverse psychology. Like anything that I ask for, he wants to do the opposite just because he doesn't want to give me what I want. I really wonder about that. And I talk about that in the video Meta Rulings. Definitely take a look at that video. I know I mentioned it before. Conclusion. I am requesting modification reluctantly and because after 2 years, my gross monthly income has steadily declined. Here we have my declaration under oath, swearing that this document, or at least all of the facts alleged in this document, are true and correct under penalty of perjury. Here we have my Rule 5 Certificate of Service, indicating that I served this document upon my ex's attorney by taking it to a law office and physically handing it to one of her staff. Here we have my motion opposition notice. This is actually, I think this counts as a $25 filing fee motion. Yeah, it looks like it does. So if you answered no to question 1 or 2, or yes to questions 3 or 4, you are exempt. Oh no, so I answered yes to question 3, so I'm exempt, so I don't have to pay a filing fee for this. List of exhibits, pay stubs, degree progress report, and 2 articles, so it looks like these are all new, so we'll take a look at them. Exhibit 1, we have my paycheck. Guys, you know how paychecks look. I'm going to go ahead and skip through these. You can take a look at them yourselves. Go down to the description below, click on the link, download the document. Check out the paychecks. If you have any questions, go ahead and post those questions down in the comments below, and I'll answer them to the best of my ability. Exhibit 2, academic advisement report. Again, this isn't really a legal document, guys, so I'm going to go ahead and move through this document. Same thing as I said before. If you're interested in this specific exhibit, go ahead and download it, review the document for yourself. But all this does is indicate how close I was to graduating, and it proves that I'm not a genius. Because if you look at this, you're going to see all sorts of C's and D's. I graduated with like a 2.07. So, you know, a lot of people who think I'm a genius, I'm not. I mean, if I was, I would have had a 4.0. So if I can, you know, litigate through the court system, you can too. It's hard. It's a pain in the neck. It takes forever. And a bunch of times I lost in the beginning, but eventually, you know, an average person can figure it out. You know, even the last couple semesters were not straight A's. I mean, I got better grades, but I didn't get straight A's. I struggled. Exhibit 3, we have the average salary of an entry-level software engineer. Again, since this is not a legal document, I think I'm just going to glaze through it, guys. But I just went through some Bureau and Labor statistics to show that I was trying to increase my income, that increase would result in child support from my ex, that I wasn't trying to do this in bad faith, and nobody cared. Judge didn't care. Her attorney didn't care. And then we have here another document on software engineering, which is going to show an increase in salary. Moving on, all these documents are non-legal. You guys can go ahead, take a look, bring up anything you want down in the comments below, and I'll address it. Okay, we have my Affidavit of Employer. So I even got my boss to help me out here. And I was in, this makes me even more angry because most people go to court and they tell the judge, trust me that I'm not willfully underemployed. And I went above and beyond. I got an affidavit from, it's just like, what more could you do for this judge to let him know that I am not willfully underemployed? And he doesn't care. So here we go. My boss is stating to the court that I am employed part-time. At her request, at my boss's request, I'm part-time due to the economic impact on our industry, not because I've indicated that I'm unwilling to work more. What more can I do for this judge? This is why people hate the legal system, because you bend over backwards and they still don't listen. Moving on to the next section, Certificate of NRCP 5, which indicates to the court that I have provided this document to my ex's attorney by personally taking it to her law office. Notice of acknowledgment of Rule 4 service. My wife here is indicating that she's been commanded to appear by subpoena to testify, and that she's basically waiving her right to get the witness fee and all that stuff. Oh, no, wait, she's saying she got the witness fee. So I gave her the fee. It's kind of funny. At the time, she wasn't my wife, guys. She was just my girlfriend. So she got the witness fee, and she's saying that she'll appear at the hearing and she doesn't need me to have her commanded to appear by like a process server, stuff like that. Subpoena. This is for my wife. She's being commanded to appear as a witness to testify on my behalf. And this is regarding the homework packet, guys. This must be regarding the contempt of court homework packet issue. And this is just a subpoena. I've gone over several of these in this My Docket series. And here's my Rule 5 Certificate of Service indicating that I've given a copy of this subpoena to my ex's attorney. Going into the aftermath, we have 1, 2, 3, 4 documents that I filed, but they were all for, no, the subpoena wasn't a free filing. I had to pay the witness fee there. It would have been $26 plus 26 cents per mile. In Reno, pretty much anyone could get to the courthouse within just a few miles. I guess unless you were like in Stead or something. I'm not going to bother counting the 26 cents per mile because it's going to amount to peanuts. So I'm going to go ahead and say that I incurred $26 in costs for my wife's subpoena. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably spent 5 minutes with the affidavit of the employer, because that's a disconnected witness. That's an area of concern for that attorney. 5 minutes for, I guess, the notice of acknowledgement and the subpoena combined, which comes to 10 minutes. And then we have the motion to modify child support. It's not too lengthy, and it's nothing that the attorney hasn't seen before. It's standard law. So I think 20 minutes is reasonable there, which is going to take us to 30 minutes. And at the rate of $250 an hour, that's going to come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.